Our witnesses for this evening's session as we continue to do our statutory review of the provisions of the Criminal Code relating to medical assistance in dying and their application. Tonight we have the pleasure in the first panel of having Dr. Raphael Cohen-Almagor, Professor of Politics at the University of Hull, as well as Monsieur Pierre Deschamps, who is a lawyer and ethicist. And we also have two people from the Dying with Dignity Canada organization. We have the Honorable James Cowan, member of the Board of Directors and also a former Canadian Senator, as well as Helen Long, Chief Executive Officer of Dying with Dignity Canada. Just a few quick rules. D'abord, je sais que vous appréciez tous.
Know that you all understand the health measures that were put in during this COVID period. So all of those who are in the committee room, I would please ask you to abide by those rules.
And panelists this evening, just a few small details. You may speak in the official language of your choice, English and French. We have translation. If there are problems for you hearing translation, please let us know. We'll suspend and fix the problem before we get going. Secondly, please don't speak until I give you the authorization to speak. If you wish to draw my attention to something, there is the raise hand feature on Zoom, so you can use that. And when you speak, please speak slowly and clearly. The way we proceed is that we will begin the evening with the three panelists each speaking for 5 minutes, and then we will follow that with a question period. Alors, sans plus tarder, we'll get the show underway. Dr. Cohen-Almagor, if you are ready, the microphone is yours for the next 5 minutes.
Good afternoon, good evening. Thank you for your invitation to present my views on end of life today. My name is Raphael Cohen-Almagor. For more than 30 years, I've been studying end of life concerns. Ethically speaking, I think patients should be able to receive medical aid to end their lives. This should be done in the most attentive and careful way. I restrict my reasoning to autonomous patients who are able to decide for themselves. Incompetent patients are, by definition, not autonomous. As they are unable to decide for themselves, the road for potential abuse is wider. During the past decades, I served as a consultant to several legislatures on end-of-life treatment. Inter alia, I served on the public committee that legislated the dying patient law in Israel. I submitted to you a specific section of the law that addresses advance directives. Advance directives are problematic. They are often made without the opportunities for full informed consent. On what basis did the patient make the decision that she would not want to be treated? The decision not to receive treatment should be based on a clear understanding of the situation. It is essential that the patient understands the disorder, the available alternatives, and her chances and risks. This can be rather complicated when the physicians themselves do not have a clear picture about the condition and cannot provide a reliable prognosis. My research in 9 countries, United Kingdom, Canada, Israel, United States, Australia, New Zealand, the Netherlands, Belgium, and Switzerland, shows that there have been a number of cases where physicians playing God have abused their position on authority to make decisions that are not in the patient's best interests. Also, end-of-life care is often compromised due to economic consideration and a shortage of resources. The research has evidence that advance directives are often made without an opportunity for full informed consent. For example, in the United States, advance directives might be utilized by medics against the patient's best interest to save costly resources. The research shows that advance directives have not fulfilled the promise of facilitating decisions about end-of-life care for incompetent patients. Many legal requirements and restrictions concerning advance directives are counterproductive. Despite their benevolent intentions, they have created unintended negative consequences against patients' wishes. Let us examine the highly problematic case of dementia. As you may know, medicine at this point did not fully decipher the mysteries of the brain. We know a lot about the heart, about the lungs, about the kidneys, and about other organs. We are yet to fully understand the brain. The human brain is struggling to understand the brain. Therefore, caution is a must. In the first stage of dementia, patients tend to suffer from fears of becoming a burden on loved ones and the medical care, losing independence and losing one's dignity. The suffering is mental. The suffering can be alleviated with due holistic palliative care that addresses the patient's mental, psychological, physical, and social needs, with assurances that the patients have an intrinsic value notwithstanding their deteriorating condition, with family solidarity and with compassion and respect for the patients who are now at the junction when they need attention more than ever before. As patients with dementia tend to be elder adults, they should be assured that it is payback time. All their lives they gave to others, their children, their friends, their society. Now it is their turn to receive. The moral imperative is to provide compassion and care for people with dementia. With the advance of dementia, its distressing symptoms become more frequent. Pain and agitation become more common as death comes nearer. But generally speaking, these are treatable symptoms. Studies have shown that cognitive behavioral therapy, palliative, and hospice care could greatly improve the care of patients with advanced dementia. Patients with dementia who receive hospice care have fewer hospitalization and milder psychiatric symptoms as compared with those who did not receive hospice care. Furthermore, families of patients with dementia who receive hospice care report greater satisfaction with care. When individuals are aware of the complexities of dementia and factor in the contradiction at the end of life, whereby with severe dementia they will not be able to remember their previous wish and may well be pursuing other interests, yet they are making a conscious decision that this is the time when their own lives should be terminated, that decision is bound to be fraught with doubts. At the onset of the illness, death is premature. In the later stage, it is questionable because the patients show that some aspects of life are still meaningful to them. And in the last stage of the patients are no longer autonomous to make such momentous decision, and the physicians cannot be sure what the patients then want. The dementia paradox cannot be solved with euthanasia. It needs to be addressed by more care, compassion, and good doctoring. The medical team has a crucial part to play in promoting quality of care from diagnosis until the last stages for dementia, to assessment of changes in cognitive functioning, memory, depression, fears, communication difficulties, and behavior, alongside identification and treatment of symptoms. Early requests to die are often the result of desperation that the medical staff and the patient's beloved people can forestall by providing the understanding, support, care, and sharing that will assure the patients that they are and will remain members of the human community. What we should do,
Doctor, if I can ask you to wrap up now, because
yes, what we should do is humanize care for the living. The liberal state has an obligation to protect all people, especially the vulnerable. To resolve the conflict between past competent and current incompetent interests, it is suggested that instead of simply enforcing all prior directives, doctors, families, and other people involved in the care of incompetent patients should be able to examine whether the patient interest would be best served by action contrary to advanced directives. What is required is a careful study, accumulation of knowledge and data, addressing the above concerns, learning from mistakes, and attempting to correct them before rushing in a frenzied fashion to introduce more liberal ways to euthanize patients. Haste makes waste. Thank you very much.
thank you, Doctor. Maintenant, on va passer au.
Now we'll turn the floor over to Mr. Pierre Deschamps. The floor is yours, Mr. Deschamps. You have 5 minutes. Good evening to everyone. Thank you for this invitation. This evening, I'm going to talk about advanced requests to die. The advanced request deals with the opportunity for an individual to consent in advance to the administration of medical assistance as the person feels that the state of the person's health is not compatible with their values, and perhaps the person may not even be able to recognize the people that are around them. It's part of a trend that we're seeing to ease regulations, giving better access to MAID, as shown by the Canadian legislation on this matter. I would like to draw your attention to a few aspects. C14 has enabled an individual to have a doctor or nurse practitioner to administer medical assistance in dying. This is an exception to the section 14 that says that someone can inflict the death even if the person is providing the person is of consent. There are some safeguards to prevent the situation where the injection for medical assistance is not done in full compliance. This bill has 7 pages with additional rules enabling people to receive the administration of medical assistance even if the person is not able to consent, providing that the person has signed in advance an agreement with a doctor stating that he does consent to MAID when the time comes. Once again, safeguards have been established by the legislator to protect the individual who has agreed to receive this assistance. Now, what about a person who is not, who has an incurable disease, but who fears to ask for it, given when the time comes? For example, let's say we're talking about advanced dementia. So this person won't be able to recognize the people around him or to participate in everyday living. This person can receive medical assistance even if this person is not conscious at that time. By dealing with this, Canada has drawn on the experience of a few other countries that have got advanced directives. The Netherlands, Belgium, that have laws that are very different to ours. In the Newfoundland, advanced directives are authorized, but from 2007 to 2017, there have only been a few people who have been taking advantage of this euthanasia for advanced directives. In Belgium, if an individual is unconscious irreversibly at the time of the euthanasia, that is, if the person is in an irreversible coma, from 2016 to 2017, 23 people were given euthanasia pursuant to their laws. Unlike Belgium, Canada currently offers the opportunity to offer this administration of MAID if there is a total lack of consciousness. But in the case where the person has a serious nature and asks for AD and the person is unconscious, normally the person has to have been able to have given informed consent beforehand. Under these circumstances, the federal legislator will have to validate through the criminal code the opportunity for an individual who makes an advance request to receive medical assistance if they meet certain conditions that have been identified before filling out the declaration. If the advance request is taken into account, the declaration is we proceed with the advance request if the person is incompetent or unconscious, and whether the person has a serious condition, and the person we can determine whether the person had, in fact, in advance, expressed a desire to die. The challenge for the legislator is to come up with strong safeguards that will protect the individual who has made an AR, generally speaking, several years before the person reaches the state, so where they are no longer able to tolerate the pain. There has to be safeguards to ensure that there is no coercion by relatives, and where the individual may find themselves in a very vulnerable situation. The federal legislator in the area of the criminal code will ensure, such as the provinces like Quebec, they will have to look at the context of the AR. And when a person is judged to be incompetent or is not in a state of consciousness. Mr. Deschamps, can I ask you to come to conclude, please? So we have to harmonize the legislations between the provincial and federal governments. That's necessary to conclude the evolution of the Canadian legislation for MAID is taking a long view. We have to allow all human beings to choose the time of their death with the assistance of health practitioners. This law is not being specifically recognized, is not recognized in the Charter of Rights and Freedoms. It does touch on the aspects covered by this charter. These safeguards are limitations and help people who with incurable disease who are suffering intolerably to be able to make an advance request and to consent or to waive the consent. Thank you very much for your attention.
We'll now go to Senator Jim Cowan and/or Ms. Long. Between the two of you, I don't know if you're going to share the speaking, but you have 5 minutes. Please go ahead.
Thank you. We will be sharing our time. Dying with Dignity Canada, or DWDC, is a national human rights charity which for the past 42 years has been committed to protecting end-of-life rights and helping Canadians to avoid unwanted suffering. For Canadians, this is not an academic debate. It is about compassion, avoiding suffering, and fundamental rights. Every day we hear from individuals and families as they navigate end-of-life choice, including but not limited to medical assistance in dying or MAID. In developing our position, we sought out the insights and lived experience of healthcare practitioners, individuals with physical disabilities and mental disorders, first-person advocates, and other volunteers within the MAID community. We believe that everyone should have the right to live and the right to choose their end of life. We encourage the government to continue to invest in increasing access to palliative care and to providing additional supports for people living with disabilities and mental disorders. At the same time, we strongly support the statement made by Dr. Stephanie Green last week that MAID and community resources for mental health, palliative care, and disability supports be developed and supported in parallel. By far, the most frequently asked questions we receive are those related to advance requests for MAID. An advance request involves a competent person making a written request that could be honored later after they lose the capacity to make medical decisions for themselves. It would allow an individual to describe in writing a future state in which they would like to access MAID. We know through multiple Ipsos polls that Canadians support advance requests. Those results have been consistent over time and in line with those from the government consultation in the spring of 2020. Ipsos polling in April of 2022 indicates that 85% of Canadians support an advance request for those diagnosed with a grievous and irremediable condition, and 77% of Canadians support an advance request without a diagnosis. Canadians tell us they are concerned about their capacity to provide informed consent to MAID due to a family history of neurocognitive conditions such as dementia or Parkinson's, or that an accident or other medical problem could result in diminished mental capacity. Advanced requests for MAID would allow those who so choose to avoid a life of grievous and irremediable pain and suffering. If loss of capacity occurs, DWDC believes that advance requests should be allowed with or without a diagnosis of a serious and incurable illness. Canadians already have the right to provide advance direction regarding treatment options through personal care directives. The same right for an advance request for MAID would allow those who anticipate a loss of capacity to ensure that the guiding principles of their lives are respected when they can no longer speak for themselves. Senator Cowan will complete our statement.
Thank you, Helen. Our MAID laws have been driven and inspired by Canadians whose desire for dignity, autonomy, and self-determination have led them to fight for the right to make decisions that align with their own personal values. People like Sue Rodriguez, Kate Carter, Gloria Taylor, Audrey Parker, Jean Truchon, and Nicole Gladu. Today, we hear from people like Pamela Cross, Catherine Hammond, and the Eusenio sisters, whose experience with capacity eroding conditions motivate them to speak up and support changes to the law. DWDC recommends that the assessment of eligibility for MAID, including the requirement of intolerable suffering, as described in the advance request, be completed by healthcare practitioners when made aware of an advance request prepared previously by an individual who has since lost capacity. The advance request should be documented in a manner consistent with the current process and include a personal statement that outlines the values and interests that are central to the person's life and the core of their identity. That statement must be considered by the practitioners when making their assessment. Time doesn't allow us to go through the details of the careful safeguards which you've outlined in our brief, which will be filed with the committee, but we invite you to review them in detail, and we'd be happy to expand and answer any questions. Some clinicians have pointed out that individuals who have lost capacity and reached the point of what their advance request describes as intolerable suffering, or suffering intolerable to them, may not appear to be suffering at that time. However, the purpose of the advance request for MAID is to respect the previously expressed wishes of the person when they were competent. The safeguards and decision-making process ensure that the individual meets the criteria for assisted dying and MAID, and MAID would not proceed if the individual exhibits conscious indication of resistance or refusal. There is no evidence that access to MAID in Canada or in any other jurisdictions has had a negative impact on societal values pertaining to individuals with capacity loss. Rather, it's brought more attention to end-of-life care in general, including palliative care, and to the need to ensure that all citizens can live and die well. Thanks for your time today, and we'd be happy to answer any questions.
Thank you, Senator Cowan and Ms. Long. And that concludes our opening statements. We'll now go to a round of questions, and I will hand this over to my co-chair, Senator Martin.
Thank you, Mr. Garneau, and thank you to all of our witnesses. For our first round, we will begin with Mr. Cooper for 5 minutes, and I will give a 30-second warning, though I know in the room you can see that time clock there, just as a double check. Okay, so Mr. Cooper, the floor is yours.
Thank you, Madam Co-Chair. I'm going to direct my questions to Professor Cohen-Almagor. Can you speak, Professor, to the difference between an advance directive in the context of MAID versus an advance directive in terms of withholding life-saving treatment? If you can have the former, of the latter, why would you not provide for the former?
Is that for Dr. Cohen-Almagor? Yes.
It is.
I want to say something in general about advanced directives for competent patients and for incompetent patients. For my studies, and I said I studied this in 9 countries, including Canada, although I was in Canada last in the early 2000s, not in the past 10 years or so. you see time and again that when I asked doctors who deal with dementia patients, they tell you time and again that it might be the case that a person in a certain situation, knowing that he's going to end up without recognizing his own life or her own life and own relatives and so on. But when it comes to the end of life, they change their mind. They find meaningful, esoteric, something that was utterly meaningless to them, say a few years ago, and now they found meaning in that. So I think that when you have to differentiate between conditions, if it's physical deterioration, if it's a physical condition in which the mental capacity remains, I totally agreed with James Cohen and Helen Long about all they said. When it comes to dementia and issues of the brain, I cannot agree to that because people change and people do change their mind. I mean, look at marriage. You know, many people when they got married, they think it's marriage for life. Yet we see that 50% of the population have divorced. They change their mind. You ask a young person whether she can perceive life in a wheelchair. And the common answer said, I'd rather die. But God forbid if they enter into a state of accident, car accident, and now they find themselves on a wheelchair, they do not want to die. The majority of them want to stay living. I've seen patients in horrendous conditions, but when you ask them, do you like to die? There is silence. So I think that we have to be very, very cautious when we come to incompetent patients. For me, the issue of autonomy, something that I think all of us are concerned about, and I think all Canadians are concerned about autonomy. That's what motivates MAID, the autonomy of the patient. But I don't think that we can encompass that to incompetent patient. This is where we have to set the boundary. And the boundary should be very, very strong and very, very firm. If you're going to pass this, we are going to open the gate for abuse. And Canada does not want that.
Thank you for that. Can you speak to your work in other countries and some of the issues that you saw surrounding advance directives that you believe are a cause for concern?
Well, I spent a lot of time in Belgium and in the Netherlands. In the Netherlands, I saw advanced directives of, let's say, something like, I would like to die if I don't recognize my children anymore. Now, this is a statement by a competent patient who made it in a sane mind and so on. But God forbid it comes to later on stages. Of course, it doesn't hold any water.
30 seconds.
And of course, nobody is going to take this seriously. I spoke with I went to a nursing home in Amsterdam and spoke with Dr. Beth Kaiser, who wrote a very famous book, Dancing with Dr. D, Dr. Death. Bert is supporting euthanasia for patients, but he found it very, very difficult to support this for patients with dementia. Because he understands what it actually means, because people do change their mind, and you can't kill someone who sees there's something meaningful in something that, watching television. And now, yeah, anyway.
Thank you very much. Next, we'll have Dr. Fry for 5 minutes.
Thank you very much. This is a very interesting and a very charged set of circumstances. As far as I am concerned, having been a practicing physician for 22 years, the idea of an advance directive is that the patient, as you said, should have informed consent, and then the patient should make a decision. If they are ever going to come to a time when they are not compos mentis, they decide what are the conditions that they wish to see happen if and when they get there. That's what an advance directive is about. My question is that the Supreme Court was very clear about the Section 7 of the Charter. And then I wonder, because I hear you and I hear Monsieur Deschamps, does Monsieur Deschamps agree with the Supreme Court decision in Carter under Section 7? Do you, sir, believe that a physician should second guess a patient? A patient is concerned that there will come a time when other people will do things. The abuse, do you not agree that this abuse can work both ways? It can occur when a patient is not compos mentis and family would like to get rid of the patient. And if the patient in an advance directive said, I don't care what happens to me, I would like to continue living, families could in fact make a decision with a physician that that's not so. Similarly, families could make a decision with a patient who said, there comes a time when I will not be able to mentally make a decision, and I want to be able to die with a certain amount of dignity, and here are my conditions, being fully informed. I don't understand. This is about the patient, as far as I'm concerned. This is about the best interests and the autonomy and the self-determination of a patient who makes that advance directive because they're very concerned that other people will change it when they become incompetent. And now I am hearing people saying it's okay for physicians who don't know what it's like to have Alzheimer's, who have never had it themselves, who don't know what it's like to live in that patient's body and that patient's autonomy, making decisions for them. I call that physicians playing God. So I think the Supreme Court was very clear on Section 7 of the Charter. And I am hearing people telling me that the Supreme Court didn't know what it was talking about. And the doctors know better than patients what a patient requires, especially if they disagree with the patient's advance directive. I don't understand advance directives to be about that at all. So I'd like to hear from Monsieur Deschamps and Mr. Cohen about this. Why is it that other people believe that they have the ability to make a decision for a patient who has obviously made that decision in advance because they were scared of being non-compos mentis?
Okay, Monsieur Deschamps.
Merci.
Thank you. To answer Dr. Fry, what I said in my opening statement is that the Canadian legislation is evolving both federally and at the provincial level towards the acknowledgement of advance directives for MAID. The problem that I see, or the problem that the federal legislator is faced with, is how do you ensure that the individual who wants to have it will have it at the right time, and that when this individual is in a vulnerable stage? What I'm saying is that we're going to certainly get to this point, but for the federal legislator, well, you need to establish some safeguards to ensure that this individual can exercise this right. And what the Supreme Court said in Carter is that Canadian citizens have to bear this in mind. But when people are vulnerable, we're not trying to deny them of any rights. The legislator has to establish safeguards that are appropriate.
Not being rude, but I would like to hear from Dr. Cohen Almaguer. I understand what you're saying. And,
okay, there's 30 seconds for Dr. Cohen Almaguer.
Two very, very short comments. One is any advance directive should be restricted by time. So when I was sitting on the legislature of the Israeli law, we set up a framework in which every 5 years people should renew the living will or advance directive. That's the first comment. Second, Senator Fry, you yourself put emphasis on the... Sorry, Dr. Fry.
Dr. Fry.
You put a lot of emphasis on autonomy of the patient, so am I. The question that we have to ask ourselves, what happens when autonomy ceases? And my answer is, if the autonomy ceases, then there's no euthanasia because there's no autonomy. That's a very simple sort of a border that we have to draw very, very firmly.
Okay, our next questioner is Monsieur Thériault for 5 minutes. Monsieur Thériault.
Mr. Thériault. Thank you, Madam Chair. So as not to avoid an interesting discussion, I would like to table a notice of motion, given the importance of this committee's work on MAID and the provisions of the Criminal Code and the enforcement of that, that for each section of the study, the committee set aside time to listen to witnesses as follows, and not necessarily in chronological order, but it's so 12 hours for witnesses for advance requests, 12 hours for mental health situations, and 5 hours for palliative care, and 5 for individuals who are disabled. And that the time has already been set aside to hear from witnesses as we saw on the 25th and 27th April, and that this be taken into account. So thank you very much. My first question will be for Mr. Deschamps. First of all, I'd like to welcome you here. Thank you for coming. Medical paternalism is outdated. The time of taking drastic measures to keep someone in life is no longer in vogue. There are certain so the role of the state is not to be paternalistic either, and nor to impose our idea of what's good for the patient. Rather, we have to make it possible for patients to have an informed opinion, give informed consent. I'm sure that you agree with that. Yes, and I fully agree with that, with this principle. What I was talking about today is that you, as a federal legislator, if you have to make legislation or ensure that the MAID evolves further, that it be considered as part of the as being something that is legal, considering that the individual who is faced with this decision, whether he or she wants to proceed or not, that we establish safeguards, maybe a double assessment. We have to also consider, yes, just to clarify, I don't have much time, I'm sorry. I'm sorry to cut you off, but so let's look at these safeguard measures. I noted in your statement that you were saying that it takes safeguards that are strong. What, in your opinion, would be strong safeguards? I imagine you've given some thought to this, so please go ahead. And there are two that come to mind. First of all, for MAID, generally speaking, we ask that 2 doctors do the assessment, but perhaps we should have a 3rd doctor look at the person's illness and give a 3rd opinion. Not necessarily a family doctor, but perhaps a doctor with special knowledge with respect to the disease itself. So we have to perhaps allow some time for relatives to step in. A person could say, look, my mom is getting worse. We have to do something. So we have to bear all of this in mind and let some time pass to do the assessment, and eventually we can activate the request and administer MAID and safeguarding all of the other conditions. So these would be 2 measures that the federal legislator should do if we want to have stronger safeguards, given the vulnerability of the individual at that time. Thank you.
Merci. Next, we will have Mr. McGregor for 5 minutes.
Thank you, Madam Co-Chair. Senator Cowan, good to see you, and welcome Ms. Long from Dying with Dignity. I wanted to give you a chance to respond to what we've heard so far in this session. As you're very well aware, there's several dimensions to advance requests. There's the status of the patient, the clarity of communication, there's strength of relationships, but there's also a lot of challenges. Like intolerable suffering is a very subjective thing, and for someone who is unable to communicate, it can be hard as an outsider to determine what their level of intolerable suffering is, or whether it's meeting the definitions placed in their advance request. Also, informed consent, the role of third-party decision makers, the potential conflict between anticipated and present circumstances. From both of your viewpoints, I just wanted to give you a chance to respond on how we could set up a system that takes into account those very real concerns that exist out there.
Helen, do you want to go first?
Sure. I think there are concerns and there are things that we would need to do. I think in terms of informed consent, the individual should obviously know the disease state, the trajectory of their diagnosis, how things are going to go, so that when they're describing in their advance request that point at which they would like MAID, it's a clear description. I think, the description needs to go beyond when my family can't recognize me. Perhaps it's a specific state or stage in a dementia diagnosis, and very detailed. I think it's also important to note, just in the use of language, this is an advance request. It's not an advance directive. So, the request is made. We believe that all of the eligibility requirements that exist for MAID, as outlined in the current legislation, should still be met. So the 2 assessments, all of those pieces. And then the clinician never has to go ahead with the procedure if they don't feel the individual meets the bar that's been set. It is a request. It's not a directive. And I think it's important we remember that language.
I only add, Mr. McGregor, and good to see you again, that we go back to this being about the patient and about the individual. And it's a clinical assessment by a medical professional as to competence. And medical professionals make these kinds of assessments every day in their practices. And they're well versed, well trained in assessing competence. And if there's any doubt, then obviously they don't certify the compliance with the strict criteria that are set forth in legislation. But the legislation, as originally C14 and then as modified by C7, very strict criteria, very strict safeguards. I think significantly improved by C7 because some of the safeguards that we thought about or that the Parliament put in place back when we began this journey turned out to be burdens or barriers rather than the safeguards, and so they were properly modified last year. And I think that as we learn more about the evolution of MAID in Canada, we have lots of experience here in Canada. And as I said in my remarks, there's simply no evidence of abuse, of coercion. And it is, as I say, about the individual's decision. It's not about what other people might think that decision ought to be.
Thank you for that. And I just have over a minute left. And do you have any comment on, advanced directives for care that currently exist under provincial jurisdiction? Do you have any comments on how those and a possible future federally permitted advanced requests for medical assistance in dying would interact?
Helen?
I don't believe they necessarily would. I think an advanced directive is direction around treatment you would like to receive in terms of your health care. An advanced request is a request for MAID to be carried out when you reach a state that you've identified and described and you meet the eligibility criteria. So I don't know that there necessarily is any connection between the 2 pieces.
Thank you. That's all for me, Madam Co-Chair.
Okay, thank you, Mr. McGregor, and thank you to the witnesses. We now go into the first round of questions, or the second round for senators. I will turn it back to my co-chair.
Thank you, Senator Martin. Nous allons commencer avec le...
We'll begin with Senator Mégier. Ms. Mégier, you have 3 minutes. Thank you, Mr. Chair. My question is for Honorable James Cohen and perhaps Helen Long. I'd like to ask you, If you, do you have the same ideas with respect to Mr. Deschamps with respect to safeguards, or do you have any other ideas in mind? Or do you think that the current safeguard measures will be adequate in the case of dementia or Parkinson's?
Brief, which we will be filing if it's in the next few days, we go into some detail the safeguards that we recommended. We recommend both for advanced requests where there is a diagnosis and more strict safeguards where there is no diagnosis. The main difference would be that we recognize that without a diagnosis, the request ought to be time limited. And I think one of our colleagues on the panel mentioned that specifically. We'd agree with that. We'd suggest a 5-year period that such a request would need to be renewed every 5 years in order to be considered at a later stage. But the safeguards that are in place now in C14 as modified by C7 are very very strict, and I think are perfectly fine.
Merci.
Thank you.
Est-ce que c'est votre seule question?
Is that your only question? Yes. Very well.
So we'll now go to Senator Kutcher. Senator Kutcher, you have 3 minutes.
Thank you very much, Mr. Chair. Before I start my 3 minutes, I'm asking you if you would mind asking one of the witnesses for more information. There was a statement made, quote, advance requests are often made without full informed consent, end of quote, from Dr. Cohen-Almaguer, and I'd like you to ask him to provide the data to support that statement, please. The questions I have are for Senator Cowan. Nice to see you again, Senator Cowan. And thank you for being here with us. We often hear, we've got the Ipsos 2021 research that looks at advanced directives and mental illness as a sole condition, with the vast majority of Canadians support made for both those. And I wonder if the record could also, the evidence that study could be put into the evidence record, please. We often, however, hear ideological, philosophical, and theological arguments against allowing competent people to make decisions about their own body. What's your opinion on the disconnect between what substantial majority of Canadians report and arguments that are made by other people, not the competent person who is suffering, that they and not the competent person should make the decision about MAID? And then the second question is, many physicians are well trained to determine if a patient does or does not have the capacity to give informed consent. Indeed, the Royal College of Physicians and Surgeons identifies capacity assessments as a core competency for psychiatrists, and I'd ask the committee to enter into evidence that document, which I can provide you. Given your legal experience, would you say that properly trained physicians can provide capacity assessments that might be required by the course to determine if a person has the competency to give consent for MAID?
Absolutely, Senator Kutcher. I think that certainly in my experience as a practitioner, I often called on medical practitioners to provide opinions as to capacity, and I always found them to be ready, willing, and able to do that. And as you say, they're trained. That is a core competence that they have, and physicians do that every day. And I think that some cases are, as you would know from your own experience, some cases are more difficult to assess than others, but that's what physicians do. And that is it is a clinical decision made by trained professionals and shouldn't be made by lawyers or politicians. I think it's a clinical decision, and that's what ought to be done. I think with respect to the general view that there are obviously individuals who hold a different view than I do about the appropriateness of MAID, about the whether it ought or ought not to be permitted. But again, it is a matter of individual choice. And if an individual chooses to seek MAID and meets the very strict criteria that are set forth in the legislation, then the court has said, Parliament has said, that they're entitled to access that service. And I don't believe that others ought to impose their view, however firmly held, however strongly held, that they ought to be in a position to impose that view on others. And as you've said, and as the polls which have been conducted, and I think if we haven't already, we will shortly be updating that Ipsos poll to include recent and consistent data, which shows that the overwhelming majority of Canadians of all religions and no religions who suffer from a disability or no disability, or have mental illness or don't have mental illness, the numbers are consistently high that they favor the MAID regime we have, and indeed are anxious that the legislation be amended and expanded to allow for advance requests.
Thank you, Senator Kutcher. Just before I go on to Senator Dalphond, Senator Kutcher, you made a request. I want to make sure I get it correctly. It was to address to Dr. Cohen-Almagor. And I believe what you said is that you would request that Dr. Cohen-Almagor provide substantiation or evidence to back the assertion that I think that you said he made, to the effect that MAID is sometimes undertaken without respecting the appropriate safeguards. Perhaps you could correct me if I didn't say that correctly, but that's what I understood.
Thank you very much, Mr. Chair. Yes, that's the case. But what I wrote down was, quote, advance requests are often made without full informed consent, end quote. Perhaps when we get the transcript, I can make it ensure the clarity of what I have said, so I didn't get it wrong. I think when a witness makes a comment like that, I think we need to have the data that opinion is based on.
Thank you very much. And so we're not going to deviate from our plan tonight. But Dr. Cohen-Almagor, if you understood what we've just said, and if you would be prepared to provide that information in writing to the committee, that would be very much appreciated. So we'll now go on to Senator Dalphond. Senator Dalphond, vous avez 3 minutes.
Senator Dalphond, 3 minutes. Thank you, Mr. Chair.
Cohen-Almagor, I understand, Doctor, you are opposed to advance requests out of concerns of potential abuses. That being said, is there a way, if we put up a system here in Canada with a lot of safeguards, and including ultimate check before administration of MAID, including if the patient is showing some resistance, that we won't proceed, that these safeguards will be addressing some of your concerns or maybe all of your concerns?
I want to clarify that I'm not opposed to advance directives for competent autonomous patients. I'm opposed to advance directives when it comes to incompetent patients. As I said, I sat on the committee that legislated dying patient law. In Israel, the dying patient.
Doctor, sorry to interrupt, but if you say that you are not opposed to advance requests only when you're competent, what is the difference between asking for MAID at one point and asking it in advance? You're talking about the same thing.
I'm saying that, okay, I refer in my testimony to the issue of dementia, particularly because I know that it's an issue in Canada. So just imagine the following. A person has been diagnosed with dementia. It's the starting of a process. The process can last years. At the start, if he says, I would like to die when in the later stage of dementia, now he should not die. He doesn't want to die, the patient. And then we can discern a second stage in which the dementia is advancing, and say 5 years have passed. He feels again the advance directives. Okay? You asked him, do you want to die now? He said, no, I don't want to die now. I would like to die at a later stage. You don't, so there's no euthanasia for that patient. The next time, the next phase, it's going to be too late because then the patient is incompetent. Then either you're going to die, to kill the patient
But
in the basis of advance directives.
That's not my question. So if the patient has dementia, he cannot ask for advance request. It's too late. He cannot consent to it. But if he still is competent, why are you opposed that later on, when you reach the stages that will be those that he has indicated when he was competent, that we follow the instructions?
Because maybe at that time he doesn't want to die anymore. And it happens quite a lot. Or there's no evidence
judge of
that the
that
patient wants to
situation.
die. So you want to enforce the autonomy of the previous stage of the person when the person actually changed. And what I wanted to say is that we always change all the time. When we are competent, we change. And let alone when we don't know and don't understand the brain enough to make a decision about the patient now when he's in advanced dementia. And therefore I say all the time, in any stage, the issue of advance directive for dementia patients is morally problematic. And therefore, this is where I draw the line. I have nothing against for advance directives when it comes to competent autonomous patients.
Thank you, Doctor. Thank you, Doctor. We'll now go to Senator Wallen. Senator Wallen.
Thank you very much. And I will address my questions to Senator Cowan and to Ms. Long. As you know, Senator Cowan, the Senate dealt with this issue and proposed an amendment, which was accepted overwhelmingly by the Senate to deal with that very conundrum that, of course, you have to make an advance request if you know your disease or illness will render you incompetent. That is the whole discussion, the core of the discussion around advance requests for patients, for individuals with dementia. So how do we wrestle this? We have seen in the news in the last few days endless discussions of choice and a person's right to choose what will happen to their body. How can we ensure that if we do not allow for advance requests? It's the only way we can ensure that that patient continues to have some say.
I absolutely agree, Senator Wallen. I think that's the reason why, the very reason which we have it. And I think that it's to the point that was made a little while ago about people change their minds. When you passed C7 last year, there was a specific provision inserted in there that it wouldn't, and there was a form of advance request there with Audrey's amendment, and it was specifically provided that if the individual showed any conscious indication of resistance or refusal, then MAID would not be administered. And that's certainly the case. We would suggest that that's logical to have that safeguard in place if we proceed to adopt a more expansive role for advance requests. I agree.
Ms. Long, just on the question of advance directives and advance requests, because the directives we do allow for anybody who goes in for surgery, they can sign a DNR and say, do not resuscitate me under the following circumstances. So it seems to me that we're just trying to extend that very right that we give to a patient. They don't know what their state will be when they emerge from a risky surgery. So that is why they have signed the DNR. Is this an advance request, not the ability to do the very same thing? And we could sign it 5 years in advance and 3 years in advance and 1 year in advance. I mean, if you've indicated over your lifetime that you want to make those choices, would that not be a reasonable approach?
I think it's a very similar approach. I think the difference is in the end, there's an assessment process for the MAID process and an eligibility requirement that is assessed by a clinician. So that would be the difference. But I agree, certainly you could make it years in advance. It could be renewed upon occasion. It needs to reflect your values and beliefs, things that are not, I don't think, is relevant in the case of an advance directive. But I think there's certainly ways to get to safeguards. And what we heard from the assessors and providers who've been speaking, the work that's going into building a national curriculum for MAID assessors and providers, all of those things will support the ability to put in place and adhere to appropriate safeguards.
Thank you, Ms. Thank you, Senator. We'll now go to Senator Martin.
Thank you, Mr. Co-Chair, and thank you to all of our witnesses. I have limited time, so my question will be to Dr. Cohen Almagar. There's a pretty surprising stat from Health Canada's 2020 report on MAID notes that 35.9% of the individuals who receive MAID listed being a burden on family, friends, or caregivers when asked about the nature of their suffering. So if advance requests were permitted, do you expect the percentage of people having MAID who are worried about being a burden would increase? And is that something that should concern us? Would you comment on that, please?
Yeah, if you look at the Oregon reports, Oregon was the first state in the United States that legislated end of life, physician-assisted suicide. You see that one of the repeated drives for request is the fear of becoming burden on the family. People don't like it, and therefore they rather die. And I think it's very, very, very unfortunate that that's the cause for death. And that's my call for compassion, for care, for palliative care, for helping people, not to believe and not to feel the burden on the family. I'm not sure what the legislation is going to bring about, but all of us, again, I think that all of us in this virtual room, we want to have an autonomous patient who is able to dictate the trajectory of life. And when it is influenced by becoming a burden on the family, then of course the autonomy is gone. And we would like to retain the autonomy of the patient. And that's my concern. That's why I'm here, because I want to have a say for autonomy. And I want all other factors to be at least addressed in a good and responsible fashion.
Thank you. I think we've come to the end of this hour, Mr. Garneau. So if I can take this opportunity to thank all of our witnesses for your testimony and some of the follow-up that was mentioned during the questionings, particularly Senator Kutcher. That's something we will follow up on. So we'll take a moment now to prepare for the second panel. Thank you so much. And Dr. Cohen Almagar, I know it's very late for you, so thank you so much.
Thank you.
Well, thank you.
very
So we'll
much.
suspend at this
Goodbye.
moment.
Thank
Au
you.
revoir.
Thank you. Good night.
Thank you. this evening. We have the pleasure of having with us Dr. Melissa Andrew, Professor of Medicine and Geriatrics at Dalhousie University and with the Nova Scotia Health Authority, as well as Mr. Michael Bach, Managing Director of the Institute for Research and Development on Inclusion and Society, as well as le Dr. Georges L'Espérance.
And Dr. George L'Espérance, neurosurgeon and president of the association AQD-MD.
We will begin with opening statements from each of you in the order in which I named you, and you will have 5 minutes, and that will be followed by a question period. Please wait until I give you the sign to speak. Speak slowly and clearly. Try to stay within the time limits, and you may speak in the official language of your choice, English or French. We have that translation capability. If there is a problem, let me know. We'll interrupt proceedings until we can sort that out. So with that, I would like to invite Dr. Melissa Andrew to start us off with a 5-minute opening statement. Dr. Andrew?
Thank you very much. Just the note that I practice internal medicine and geriatrics, and most of my work is with older adults or people dealing with geriatric syndromes such as frailty and dementia. And I often care for patients who are making important and potentially life-limiting decisions and regularly assess patients' capacity for decision-making in these contexts. So thinking about our discussion today, it's useful to reflect on why people might seek MAID and why they would wish to use an advance request. So people seek MAID because they have symptoms that to them cause or are anticipated to cause, as these symptoms progress, intolerable suffering. For most conditions, this does not inherently lead to loss of decision-making capacity, except in defined situations, such as progression of brain tumors and delirium at end of life. But in the case of dementia, the loss of decision-making capacity is often inherent to the very symptoms that a person might consider to be intolerable suffering. We could thus see a lack of provision for advance requests as something that impacts this vulnerable population in a somewhat discriminatory way because of the very symptoms of their condition. We should also recall that people living with dementia can currently be eligible for MAID, but it's just at a time that they would be much earlier than they might otherwise choose if they had the comfort of knowing that an advance request could be valid. What analogies are useful to how we can currently approach healthcare decision-making? So of course, we currently do allow and in fact encourage people to make advance directives to deal with life and death situations, including with reference to tricky conditions. We ask them and or their substitute decision makers to consider whether they would want resuscitation. We allow people to decline or withdraw treatments at any time in their illness journey, from pre-diagnosis to late stage. And these are sometimes called hastening decisions because they may hasten death. But in all these cases, clinicians enter into discussions with the patient and or decision makers to ensure that they're making an informed choice, that they meet the generally accepted threshold for capacity in these decisions. And assuming these criteria are met, the person's wishes regarding these decisions are respected. Regarding the question of whether there is an ethical and legal difference between withholding and withdrawing care, which was mentioned earlier, this is, of course, debated by many ethicists and others. Carter versus Canada concluded that MAID was not different from other end-of-life decisions. And so it behooves us to think about that in relation to this question about advance requests were made. What are some concerns and counter-arguments about advance requests? One counter-argument is that it would be too difficult to operationalize the exact definition of what the person has deemed to be intolerable suffering. There, of course, may be some gray areas. Indeed, our clinical work is often all about the gray areas. As an example, I've cared for patients where the degree of suffering is extremely clear to all involved, and these people live with complete torment that has not been possible to relieve despite intensive management attempts. And it's been heartbreaking to hear from some families that this person's wishes were very clear that they would not want to live in such a state and had wanted to, but were not able to request MAID in advance. Counter-arguments also bring up gray areas in interpretation. Is this the state that the person meant, and how to word the advance request in a way that allows for optimal clarity? For example, how would we operationalize a statement like, once I no longer remember my family, I want MAID? But what if their cognition fluctuates? Did they mean every family member or just their closest ones? And is it about forgetting names or a complete lack of recognition? There are safeguards to address some of these concerns that have been proposed, such as templates and detailed wording, and including consultations with appropriate stakeholders and possibly adjudication panels. Clinicians may also worry about performing MAID if the pre-stated condition appears to be met, yet the person seems content in their current life. And again, even in those cases, safeguards could be implemented, as has been discussed earlier. People living with dementia that I've heard from more often worry about distress and agitation rather than simply memory loss when it gets right down to what really defines their suffering. Another concern is, of course, the current self versus future self argument, which we heard earlier as well. And many cite evidence that people adapt well after conditions like spinal injuries once they've got the lived experience. However, on the flip side, we risk not valuing the current and often long and strongly held values and beliefs that a person now has if we're telling them what their future wishes might that they may change. And here stigma becomes a very relevant consideration. This may contribute to feelings of further marginalization in people living with an already stigmatizing condition. And some worry that advance requests may be made with too much consideration of one's burden on others and financial costs. This, of course, leads to discussions about how we provide social supports and care for people living with progressive conditions that may impair their future decision-making and how we value their quality of life. And the recent discussions of how we provide long-term care, which have been stressed beyond the breaking point by COVID, brings this issue to light. Clearly, this is something which requires a systems fix, as well as careful ruling out of coercive factors if and when advance requests are considered. In the bigger picture, it's also hard to extract this issue from the overall systems of dementia care that we have in Canada, which are suboptimal. We provide expensive care, but not necessarily good care, and we have underfunded dementia research. We treat people living with dementia in ways that do not further their overall well-being, such as lengthy stays in emergency rooms and in hospitals for behavioral expressions of dementia, which is pretty much exactly the wrong environment to have these people. This provides
Doctor,
an opportunity to advocate for action on the national...
If I could ask you to wrap up, please.
Yep, to advocate for action on the national dementia strategy. Just as we talk about the need for strengthening mental health care in the context of MAID for mental disorders, and we worry about people seeking MAID for physical conditions when palliative symptom management is suboptimal, and we appropriately see this as a time to call for strengthening those services, we must also see that this issue of advance requests for MAID is intimately tied with the quality of dementia care in Canada. Thanks.
Thank you, Dr. Andrew. Mr. Bach, you have the floor for 5 minutes.
My thanks to the joint chairs and honorable members of this committee for the opportunity to participate in these hearings. I urge the committee not to recommend adoption of advance requests for MAID for 3 main reasons. First, advance requests as a planning tool cannot deliver meaningful consent. What would it look like if advance requests for MAID are adopted into the Criminal Code's regime for legal exceptions to its prohibition on assisted suicide, knowing what the Alzheimer's Society of Canada has called the rising tide of dementia in this country? In the decades to come, more and more people who don't know what is happening to them are caused to die. Most of them are women with cognitive disabilities. Advanced care planning, in which advance requests for MAID would be added as another tool, has been shown in a series of systematic studies and reviews to be ineffective. People are simply unable to reasonably predict future preferences, capacities, or circumstances which will impinge directly on future decisions about their healthcare. And if that predictability is impossible, it leaves it up entirely to substitute decision makers to determine that a person is suffering sufficiently to intentionally cause their death. Remember that advanced care plans do not represent consent to anything. They express assumptions and wishes about future states to guide prospective substitute decision makers. In this scenario, it is the consent of substitute decision makers that determines if and when a person dies. In no way would such a practice meet the Supreme Court of Canada's requirements in Carter that assisted suicide is justified only in cases of, and I quote, a competent adult person who clearly consents to the termination of life. Valid consent was pivotal in Carter. Second, it's most likely that stigma is driving Canadians to call for advance requests rather than a defensible claim for autonomy. Although much has been said about the Ipsos polls conducted for Dying with Dignity Canada, the 2021 report poll reports that 83% of Canadians support access to MAID through advance requests. It's important to consider also the 2017 Leger poll conducted for the Alzheimer's Society of Canada. It shows that a majority of Canadians believe that people living with dementia are likely to experience discrimination, that they are ignored, dismissed, taken advantage of, or are feared, met with distrust, etc. A majority of Canadians who live with dementia confirm this experience. So given the stigma and fear about dementia that weighs on Canadians' consciousness and directs their actions and inactions, is it any wonder that a majority might advocate for advance requests to cause the death of the cognitive strangers that we project in our midst and into our own futures? Is this a reasonable basis for law reform? Is theirs a defensible claim for autonomy rights? Should we submit to the Ipsos poll when the Leger poll tells us such a disturbing story about our collective consciousness and the current realities of growing old in Canada? Surely our law reform and public policy efforts should shift to fast-tracking strategies for dementia-inclusive communities and eliminating stigma, as the 2019 National Dementia Strategy calls for. Third, it would open the door to MAID for people who are unable to consent but who don't have advance requests. What argument would there be to a substitute decision maker who goes to court to request access to MAID for their family member with a significant intellectual disability or traumatic brain injury or dementia or Alzheimer's because they are suffering intolerably in the circumstances, but they are unable to consent and don't have an advance request? Opening the door to advance requests will inevitably lead to litigation, charging that when it comes to providing MAID to people who are not competent but are suffering, it's discriminatory to restrict it only to those who have advance requests, which don't constitute informed consent in the first place. The Supreme Court reasoned in Carter that what they acknowledged as a slippery slope, their term, in other countries would not happen in Canada. They said explicitly that euthanasia for minors or people with psychiatric disorders would not happen here because our medical legal culture, their term, is so different than Belgium, for example. Obviously, they were wrong. Authorize advance requests and the hinges start to come off the door. We should remember that the justices deciding Carter stipulated that their reasoning applied to the case before them. They didn't even mention advance requests, I suspect because any such measure represents such a profound violation of the principle of informed consent, which they so clearly established as a fundamental safeguard. Thank you.
Thank you, Mr. Bach. We'll now go to our third witness, Monsieur L'Espérance.
Dr. L'Espérance, you have the floor for 5 minutes. Thank you, Senators and MPs, and Mr. Chair, the Association, Quebec Association for the Right to Die with Dignity, thanks you for this opportunity. I'm a neurosurgeon, and I now deal with the right to die with dignity. We have to, in determining the person's case, we need to respect their values, dignity in both life and death, without any medical paternalism or religious dogmatism. Our brief was transferred to you, and it is completed by many different cases. I'm submitting our considerations with respect to the advance request to die, and I'd like to touch on 2 other important topics as well. Any person who's competent, who gets a diagnosis of a cognitive disease or neurological disease, should be able to give an advance request when they are still competent, and they should be able to decide when they want to die and decide at what point. This, regardless of their cognitive state at that time. This position is supported by 95% of Quebecers in a scientific survey conducted in Quebec. In February 2016, when we were studying C16, this was what the recommendation 7 of the Joint Committee had to say about it as well. In Quebec, a special committee of the National Assembly tabled on December 8th, 2021, a very in-depth report on this subject, and you probably are aware of this. I would clarify that as a neurosurgeon, and in the opinion of many other experts, that a person who is in later stage of dementias, when this person decides to change its mind with respect to MAID, because others decide that this person looks good, whereas by definition, this person is no longer the same person. This is an insult to the intelligence and is a negation of this person's personality and his life. I would say that MAID is not competing with palliative care. It is a compassionate tool in addition to what is now offered. MAID would not take away anything from palliative care, financially or otherwise, and there will be no cost to the system. Think about the existential suffering. The person did not look forward to this. We need to eligibility for MAID brings peace of mind to individuals for those, and allows those people to decide the time of their death without unbearable suffering and losing their dignity from a disease which will lead them to death. You perhaps have witnessed the pain of seeing a dear one sink into dementia. Where the person is almost without life. Our recommendation is that we should allow MAID-AR further to the confirmation of a degenerative disease, and at the time when the person is decided in advance by signing a declaration. To exclude mental health will only lead to court challenges, a long process, and it's not acceptable for those involved. Our recommendation, therefore, is that MAID should be available to people with mental health diseases by 2023, and we will obviously have strict safeguards developed by experts. We also feel, and this is another recommendation, that we should completely prevent individuals who are individually impaired must not have access to MAID. And finally, the association believes that MAID should be broadened right now. And for people we suggest that this should be accepted to mature minors aged 14, 18, with the exclusion of those who have mental health pathologies. Thank you very much, and I would be very pleased to answer your questions to the best of my ability. Thank you for your testimony. I will now turn the floor over to my co-chair, Senator Martin. Thank you.
We will begin with questions from the House, and each question will have 5 minutes, and I will give a 30-second warning. So let's begin with Madame Vien for 5 minutes.
Thank you very much, Madam Chair. Thank you for the witnesses for coming here this evening. This is a subject that is very important. It's very moving. It's not an easy issue. I'm a former minister of the Quebec government, and I voted in favor of MAID at that time. I see that Quebec is urging the current government to proceed with the changes and with respect to MAID. But I find this all very interesting. The studies that we have done at that time is that, well, enabled us to ask good questions. We must not venture blindly. This evening, we see witnesses with very differing views. Dr. L'Espérance, there is a group earlier. It was a group led by Senator Cohen and Ms. Long. They said that we must proceed. What you're saying is no. No, you need a diagnosis because any individual could ask for a MAID despite what may happen to him or her in life. Let's say a brain injury. These elements are covered by advanced directives, but MAID cannot be requested by an AD. We're asking that advanced directives for MAID can be completed by a patient who has received a diagnosis of a degenerative disease or a cognitive disease. It seems to me, and not only to me, all our colleagues agree with this aspect, that a diagnostic has to be given, whether it be for Alzheimer's, Parkinson, or any other type of disease like that. What about mature minors? Mental health is going to be part of our thought process. We will not be dealing with that this evening. We're going to deal with what we have on the table today. That is the advance requests. As a precautionary measure, what should we be thinking about? For anticipated directives, I think that the proposals made by Quebec, you're going to find I'm a bit chauvinistic, but I find that Quebec's proposals were very reasonable. A relative, a trusted person, or a substitute is going to tell the health care of the patient's condition, tell them when he wants to die, and then the evaluation will be done by the health practitioners. It's never taken, the evaluation's not done by just one person alone. There's a whole team involved, and I have absolutely no problem in there being some type of 3 months, 4 months, 5 months that could lapse between the time of making the decision and the time where the person has asked for the actual date of MAID. So the safeguard measure would be a time limit to assess. But the other problem is competence. But when you're talking about someone with neurological problems, the person, it doesn't happen just at one, but the person may reaffirm that they do want MAID, but this can be done through a test of his competence every 2 years if you want, as soon and when the person is no longer competent, well, then we can conduct a formal evaluation. And earlier a witness said that this request should be made at regular intervals. Well, the problem with that is what should this be? Every 3 years? And after 3 years, well, perhaps a person is no longer competent. So then you're stuck. That's why these safeguard measures should include having some type of test of competency to see if the patient's changed mind. I know that we see in your career, have you seen any problems where things have gone off the track? Not in Quebec, absolutely not. When there are questions that are more sensitive, we have a forum of doctors. It's confidential. Same thing with CANUP in Canada. Difficult cases are discussed by this. I don't have much time. If I may, could you please refer your surveys to us because I think that would be very useful. Thank you very much. We will read them. Thank you. Thank you very much, Madam Chair.
Next, we'll have Monsieur Arsenault for 5 minutes.
Thank you very much, Madam Co-Chair, and I'd like to thank all of our witnesses. Dr. L'Espérance, I will piggyback on the question put by Ms. Fien. There are some people are for, some people are against, but you are in favor, providing that there's a diagnosis. So you've given some examples of neurological diseases. You talked about strokes. It's the same thing. So there may be cases, even amongst young people, where the first time it happens, it will be the bad time it happens, in the sense that this person will no longer be able to say, okay, now I want an advance request or a directive. Perhaps I didn't express myself correctly, but cognitive diseases and neurological diseases such as Alzheimer's, that's one type of disease, but that doesn't exclude things, people who, it does not exclude things like strokes. That's a whole other chapter. And these patients, either they've done an advance directive, which is quite rare, or if they haven't done them at all, the burden for the decision making is on the shoulders of the family. So essentially, we have to decide whether they want to prepare to go ahead with drastic measures. That's a whole other ball of wax. So yeah, you did express yourself properly. I didn't understand exactly. So thank you. Now, for diseases that are like Parkinson's or Alzheimer's, those are the most common ones. When the person gets the diagnosis, and I live in a rural region, so you have to bring the person to see specialists. Sometimes this is difficult to do. Theoretically, could someone who has been diagnosed, but that person might be so advanced that that he or she is not objectively able to make such a decision for an advance request? Is that possible? I don't have any figures to provide you, but based on my experience and my 30 to 40 years of experience, it seems to me that that's very difficult because when people start having memory loss or judgment problems, generally speaking, they see a doctor. And in most cases, it's the family doctor who will make the diagnosis, decide that this is a neurological disease. And then for a more specific disease, yes, a neurologist or a geriatric medicine will have to intervene. Now, I would like to turn to Dr. Back. You seem to be saying that disabled people don't suffer because of their disease, but because of a lack of services to help them with their disability. I sat on the first joint committee on MAID, and I remember the former Minister Fletcher, who was a paraplegic, he said, I don't have suicidal thoughts. I'm taken care of. I get good treatment. But if one day I decide that I want to ask for MAID, I don't want anybody else to try and change my mind. So what would you say to this case?
I certainly accept that people live with grievous and irremediable conditions that cause them immense suffering. Some of that is motivated by lack of supports, but not, I know in many situations, that's not the case. I guess my point this evening is it's very problematic to introduce these authorization for advance requests because advance requests are not consent. Remember, so someone that is going to be authorizing the death of someone else is a substitute decision maker. That's the problem here. I mean, when you make an advance request, as the special commission report in Quebec to the National Assembly table in the National Assembly in December said, yes, advance requests should be made in a free and informed manner, but that's not about consent to something that's going to happen in 5 years. Only substitute decision makers are. And I think we just have to have our eyes wide open to the reality that we're going to have substitute decision makers causing the death of another person who has no idea what's going on. They are not consenting to their death. You can't consent to the death years in advance because you don't know the circumstances. Informed consent is all about understanding the circumstances in the current moment.
Okay,
so
thank you, Mr. Buck.
Crossing the Rubicon.
So we'll go next to Luc Thériault for 5 minutes.
Thank you. My question is for Dr. L'Espérance. One witness, Dr. Cohen Amaga, who was in the previous panel, said, and here are my questions for a neurosurgeon. He said that we don't know the brain well enough to think that we could really intervene with these advanced requests. What is the state of the brain when you get to the point that you're at the final stage? Well, listen, I'm a neurosurgeon. I'm not a neurologist, but that being said, when a brain works well, we can see that the patient is operating well, working well. We can check the person's competency, and that's what we do on a daily basis by operating them, by answering their requests. The first thing that we do is we assess their aptitude. Now, if the person is suffering from dementia and is no longer competent, what is the state of the brain at that time? Well, the brain is not working as well. How can we say on the one hand that the patient is no longer competent and we don't know whether we've taken the right decision, whereas throughout this person's life has said, I want to end my days when I get to this point. So it's this aspect of the argument that I have difficulty with. Certain witnesses said yes, but it's no longer the same person. So the person who is making this request for it, and we can imagine this is a very somber moment. He's there with his doctor. He expresses his wishes, and it's a disease with various stages. It's no longer the same person. What would you say to this argument that it's no longer the same person when we proceed? It's not the same person that he was for 70, 80 years. Why all of a sudden, when this person is suffering from dementia, why the person is not the same person? He no longer has a brain that enables him to work the way it worked all his life. Moreover, we, on a regular basis, take decisions that who have cognitive problems, who have had accidents. We make a decision for them because they're no longer there. They're not able to say that, yes, I want to die. The other people have to make the decision for them, and we don't want drastic measures taken. This is done on a regular basis. We make a decision with a family, with those close to the individual, but it's not the same person we're looking at. I asked Mr. Deschamps a little bit earlier, and he talked about stronger safeguards, about getting 3 doctors to get involved in the evaluation. Are we not running a risk where we're setting so many conditions that we make the whole process almost impossible? We put so many obstacles in the way. Yes, you're right, to answer your question, but up until now is what we know here in Canada for about 6 years, there has not been this slippery slope. A doctor assesses the patient, a second one or a nurse practitioner assesses the patient to see whether he or she meets the criteria. And to my knowledge, and according to what the Quebec Commission said and the coroners in Canada said, there have not been these types of problems, to my knowledge. But once again, we have confidential discussion groups in Quebec. Same thing in the rest of Canada with KEPAP, where we look at the issues, and some people are going to say, no, we shouldn't proceed, but the whole issue's discussed clinically. And I would conclude by saying these are decisions that are made on an everyday basis in cardiac surgery and neurosurgery. The decisions are made collegially. Thank you very much.
Merci. Next, we will have Mr. McGregor for 5 minutes.
Thank you, Madam Co-Chair. Dr. Andrew, I'd like to start with you. So in your opening remarks, you were going over the advanced directives of care that, are currently allowed in our provincial medical system. So, patients, before they're going through, say for example, a major surgery, They could talk about a do not resuscitate order. There also could be different examples of withdrawal of care. Could you just tell us what are some of the more common forms of withdrawal of care? Is that like, you know, if a machine is breathing for them, can you just elaborate on that?
Sure, yeah. So really, thank you for the question. So really, these decisions, you can think about them as happening at every stage along somebody's entire journey. So, and even people who have no symptoms at all, they may decide for good reasons that they can justify that they do not want to have testing, screening, examinations, x-rays, because they don't want to know what they would find and they wouldn't want treatments, or they don't want to go down that road. So they could decide that before they even have any symptoms. They might decide it when they have a symptom, such as they have a chronic cough or they've been losing weight, and they again may consider their options and decide not to have the investigations because again they don't want to go down that road, even if it would potentially identify a cancer or something that could be potentially treated and have some lengthening of life. Somebody who's diagnosed with a probable serious condition, so say they have a mass identified on the first stages of imaging or testing, they may decide that they don't want to have further investigations like a biopsy to find out what it is. Again, because they do not want the treatments that would put their quality of life in jeopardy once they weigh the options. Someone who has a diagnosis of a serious condition, again, may decide that they don't want any recommended treatments once they have the options in front of them. Surgery, chemotherapy, radiation, these all come with very significant impacts on people's quality of life and well-being. People who have kidney failure, for example,
Andrew,
may decide that they don't want dialysis.
Dr. Andrew, sorry just for interrupting. I just wanted to give you a specific example. Say, patient's about to go through a major surgery. Something happens, major blood clot hits them, and they are left with a debilitating stroke. So completely unresponsive, basically brain dead. They've given advanced directives of care specifying, withdrawal of care. I mean, like, so if they could it be like, if I'm in this condition, I don't want you to feed me anymore. I want you to unplug the machines. Are those specific examples?
Yes, they are.
Okay,
certainly, yes.
So in that case, you've got these advanced directives of care. A patient suffered a massive debilitating stroke. How then does our law allow for them, like, because we're talking about consent. So how is consent understood in that case where a patient is unresponsive, they're brain dead, but you have to listen to the directives they gave you earlier, right? Like, we're talking about consent. They're obviously not able to give you consent, but you are withdrawing the care that is keeping them alive.
Yeah, and part of why we do that is because we want it to be based on what they would want. And that's why we listen to an advance directive, preferentially to just deciding of what's in their best interest.
Exactly.
Of course, the ideal advanced directive might include naming it a substitute decision maker who can help walk through the different options that are there presented in front of them. Somebody who's trusted and chosen by the person.
Absolutely. So yeah, we do have real world examples right now where people are unable to give current consent, but they have very specific instructions that allow people to make decisions that will ultimately result in their death through withdrawal of care, because that is what they specified. My final question to you, from a physician's point of view, what are the specifics you would like to see in a statement accompanying a possible advance request? If we are going, as the Parliament of Canada, going to allow this, if you could just talk in the last 30 seconds about some of the specifics physicians would really like to see, because you talked a lot about clarity and how we want to see that. Mm-hmm.
Yeah, I think the detail would be really important. Again, my examples were like not just when I don't recognize my family. I want to understand really where that request is coming from, what you mean by that, and give people enough education around creating these advance requests that they understand what elements of the symptoms of their condition that they might have would be the troublesome ones to them. So maybe it isn't that they forgot what they had for breakfast, but it is that they are completely traumatized anytime someone comes near them to help them with their incontinence product or something like that, because the suffering can be quite severe.
Okay, thank you very much. I'll turn this back to our co-chair as we go into questions for the senators.
Oui, merci pour la ronde des sénateurs.
Thank you very much. We will now begin the senators round. We'll begin with Senator Meiji. 3 minutes. Please go ahead, Senator Meiji. Thank you, Mr. Chair. Before I ask my question, I'd like to suggest that the report on the evolution of end of life be tabled, and the other document comes from the Quebec College of Medicine's a position paper on MAID. The one for the Quebec National Assembly was published in 2021, and the College of Doctors, December 10th, 2021. My question is for Dr. Andrew. You accompany people who are suffering from dementia, and when you talk about broadening MAID, that does involve a slippery slope. For this particular type of clientele, what do you fear when we talk about advanced requests?
Sorry, I was relying on my French, which I'm mostly following. So you said les dérives. So what do you mean by that?
What we call the slippery slope. The slippery slope.
So most of my discussions with people living with dementia have been expressing indignation, essentially, that they are not taken seriously with regard to their own wishes, because perhaps a future self is valued more than their current self. So of course there could be slippery slope arguments that, you know, if somebody makes a request that it's taken too far, or that, you know, somebody who's thought to be a trusted decision maker, you know, maybe makes a decision that is in their own self-interest as opposed to in the person's, or that are, you know, constrained despite, you know, what we hope, by economic or social circumstances, because we know that a lot of people, particularly in their senior years, and especially those who've got chronic medical conditions, do, you know, have difficulties in terms of socioeconomics and living situations and housing and whatnot. So one can imagine, I suppose, different ways that things could be taken too far in a slippery slope type of argument. However, maybe I'll bring it back to just the other slippery slope is maybe the uphill slope, that we don't allow people to exercise what they wish in their current state.
Merci.
Thank you. Do you have any further questions? No, that's fine. I can give my remaining time to Senator Kucher. Thank you very much.
You have 3 minutes.
4 minutes, I think. Thank you very much, Mr. Chair. Before I ask my questions, I wonder, Mr. Chair, if you could request some information from Mr. Bach, a written note to this committee providing the data that documented the evidence to support the statement that he made, quote, "Stigma is driving advance requests instead of the need for autonomy," end quote. That has to be an evidence-based statement. So the questions start with Dr. Andrew. I would expect that an individual who makes an advance request be competent at the time that they made that request. Is that correct?
Yes.
Are you properly trained to make a capacity assessment of a person's ability to provide informed consent about acceptance of treatments and withdrawal of treatments?
Yes.
Therefore, capable and competent enough to make a capacity assessment on someone who makes a request for MAID?
Yes, I think so, not having done it yet. I do think so because it would be based on the same principles of the person understanding the facts, applying those facts to their situation, reasoning pros and cons, manipulating that information, and then considering alternatives and being able to communicate that choice. And making sure that it's being done without coercion. So yeah, I think it would be very imminently possible to do. But I also think that it would be important as part of this, if it were implemented, to include education for clinicians, physicians and nurse practitioners who'd be in these roles, to ensure that they have the training to adapt their existing expertise on capacity assessments to an advance request.
College and the College of Family Physicians is now in the process of certifying such a program. The last part of the question is for Dr. L'Esperance. Always nice to meet a neurosurgeon, particularly at this distance. I'd just like your comment on a comment we heard earlier, quote, when a person feels they are a burden on the family, their autonomy is gone, end of quote. Would you agree that because you feel a burden to your family that you lose your autonomy as a human being?
I don't think that we could say that the patient has lost the autonomy. I don't know on what basis someone would say this, but I would go back to Dr. Marcel Boisvert had to say. He was an important heart doctor. He said even if an individual who is very elderly says that he doesn't want to become a burden for his family, is this pathological? It could be a reaction, an altruistic reaction, which is quite acceptable. Of course, we always have to bear in mind that these patients evolve over a long period of time. Things don't change from overnight. There's when you're dealing with an advance request for MAID. I hope I've answered your question.
Mr. Kutcher?
I think I'm out of time, Chair.
Yeah, you're just about there. For Mr. Bach, just to note that Senator Kutcher made reference to something that you said about stigma being a driver. So we will follow up with you. He is asking for more corroboration and elaboration on that statement that you made, but we'll follow up with you after this session. We'll now turn to Senator Delphon.
Merci, Monsieur.
Thank you, Mr. Co-Chair. My question is for Dr. L'Esperance. Unfortunately, we have not yet had access to your brief, but I see that you did table it last August before the National Summit. You proposed that we have requirements with respect to advanced directives. I would presume that you still have the same opinion as was set out in this brief. It's useful to point out that it is good to have an advance rest for MAID before there's a complete deterioration so that the person is able to be aware of the moment. And do you feel this is based on your experience? Is that based on your experience? And also, do you have any statistical data that supports this affirmation? Statistics, not to my knowledge, but that's our common experience. It's a common experience of those who are involved with MAID, those that I know. The experience right now comes from patients who have a diagnosis of a neurodegenerative or cognitive disease, and they proceed with MAID after 3 months, 6 months, or a year because they can obtain MAID, but they're still competent. So they're losing months or years. And since March of 2021, they know that they won't have to go through this long period of suffering. That gives them serenity. I've seen people go to the hospitals to get MAID. They are dressed in their suits. They've got flowers. They get all the doctors who have done this, they have seen this. They see that the person is no longer anxious. They have serenity. And this also applies to people who have cancer, Alzheimer's. We have all had this experience. So the legislation as it's written, if there are people who choose MAID and who die prematurely, that's where the debate is. We're talking about weeks or months, even 1 or 2 years, which might be well spent with their family. But they lose their competency and they're no longer to proceed with an advanced request. Thank you very much, Dr. L'Esperance. Thank you, Senator Delphine.
To Senator Walland.
Thank you very much. I'd like to hear from Dr. L'Esperance and also from Dr. Andrew. Sorry. I just want to have your comments from both of you. I'll just make my point and then have you respond to it and agree or disagree. And I just want to follow up on the comments made by Madame Vienne and other of our colleagues on the catch-22 that we find ourselves in when it comes to dementia or Alzheimer's. Some witnesses have argued that you need a diagnosis for an advance request, but once you are diagnosed, you then are by definition considered incompetent. So that's the bind that people find themselves in. And I think we heard testimony here that an advance request does not equal informed consent when in fact that's exactly what it is. You're making that request in advance when you are still competent. So could I have both of you just speak to that issue? You'll probably have about a minute each. Thank you.
Few seconds before giving avant de donner le micro.
Before I turn the floor over to Dr. Andrews, the patients who have a neurodegenerative disease, they get a diagnosis of dementia and who are still competent. Why? Because they're wondering why they're having judgment problems, memory loss. They go to see the doctor and the diagnosis is given then. They're at that point still competent to, they're still able to drive their car. So in my opinion, it's essential to have a diagnosis. I turn the floor over to Dr. Andrews now.
I agree with that totally. It's just it was represented by others in a different way.
Okay.
Thank you. Go ahead, Dr. Andrew.
Totally agree that the diagnosis does not necessarily mean incapacity. That's a separate question and would happen later. I would add the point, though, that is quite important that in some places, unfortunately, we do lack access to diagnosis. And so some people do unfortunately get a diagnosis quite late in their journey, even if they've been trying to get it earlier. And that speaks to our systems of dementia care needing to be strengthened.
It's as if informed consent is becoming a question of timing, depending on where you live and what the nature of the progression of your individual disease is.
That's an interesting point. Yeah. So it does rely on having the if you require a diagnosis, does rely on the diagnosis having been made early enough and all the education that will go along with making these decisions being done early enough before the lack of capacity. Yeah.
Is there time? Go ahead.
Les démences sont un processus.
Dementia is a process that is relatively long for the vast majority of patients. It takes several years. Maybe there are some locations, maybe in the far north, where this would be more difficult, but based on our experience, even if the healthcare system is not always adequate, people do get their diagnosis in 1 or 2 years. They can have a consultation, and the family doctors are generally able to diagnose neurodegenerative diseases. Thank you.
I'll go to Senator Martin.
Thank you. Thank you to all the witnesses this evening. So my question, I just have one for Mr. Bach. What is the difference between an advanced medical directive for medical assistance in dying and an AMD for withholding life-saving treatment? I know we've been hearing various responses, but if we have one, why not the other? Mr. Bach?
I think they're quite different. Advance requests or directives for withholding treatment are about things that aren't going to be done to us. All of the examples that were listed earlier by Dr. Andrew were about things that you refuse to have happen to you. And we've provided for that under provincial territorial law on the basis that By refusing certain things, I do exercise control in the sense that I will allow my death to take its natural course. Providing advance requests, I would still submit that you cannot consent. There is no consent to the termination of your life at a future point. There is a substitute decision maker that has to decide now we'll do the injections. So you're not consenting, someone else is. And that is to have something done to you that is intended to cause your death. That's fundamentally different than advance directives for withholding or withdrawing life-sustaining treatment, at which time comfort care, palliative care is provided to support you through the natural course of your death. And those who provide that comfort care and withhold those treatments, again, on the decision, not guided by your advance directive, but on the decision of a substitute decision maker at the time. I'm sure many around the table here have been in these decisions, that now is the time to withhold that treatment so that my son, brother, father can pass. So they're fundamentally different, and I think collapsing or blurring the line between them is leads down a path that puts one of the most vulnerable minorities at risk in this country. Because what is a democracy after it all? It protects the rights of minorities. And the minority I'm talking about is people with dementia who cannot consent, do not have capacity to consent, or people with intellectual disabilities who do not have the capacity to consent to their death. That's the group that we're protecting here. Not those who can make advance requests. The group that we're talking about here is the group who cannot consent, don't have the capacity to consent to a proactive intervention on the part of a medical professional intended to cause their death. So are we in this democracy protecting one of the most vulnerable minorities in our society? I think the proposals that are advocating for adoption clearly do not meet the test of protecting the right to life of one of the most vulnerable minorities in our society.
Thank you. Thank you, Senator Martin. Thank you, Mr. Bach. That will bring our panel to a close. On behalf of the committee, I would like to thank Dr. Andrew, Mr. Bach, et le Dr. L'Espérance. Merci pour vos témoignages ce soir.
Thank you for your testimony this evening on a subject that is very complex and difficult, sometimes emotional, as we all know. So we appreciate you bringing your experience to this committee, and we're very grateful to you.
Members and witnesses, this meeting is adjourned. Thank you.
Merci de votre écoute.